And today we're doing another session of our Facebook Live, and we're going to be discussing family law issues. We'll take some questions, live questions that come directly from the audience. Um, and it looks like, as is often the case, we experience some technical difficulties, but I think we're going to resolve those shortly. Looks like we're good to go. So if that's the case, let us take our first question and let's talk about family law and see if we can resolve some issues.
First question.
First question.
The first thing, my ex is getting remarried. Can I stop paying spousal support?
Here's an excellent question about spousal support. It comes from a man in Livonia. X is getting remarried. Can spousal support be stopped? Well, this is a very good question because it highlights the parameters of spousal support and judgments of divorce. So what ends up happening is that the judgment that ordered the spousal support will typically set forth the parameters. It may very well say that spousal support terminates upon remarriage. However, it may also say it continues until further order of the court and not specifically triggering termination by remarriage. So therefore, number one, you got to look at your judgment of divorce. You got to see what it says. If it doesn't say that it ends upon remarriage, the presumption that it does not, you can still file an appropriate motion to terminate support if there's a change of circumstances. And one might argue that the remarriage and the other means by which support can be obtained is a substantial change, and therefore something that the court might consider in terminating the spousal support. But of course, that's going to be up to the judge. Clearly, if your judgment specifies that it terminates upon remarriage, that should be a pro forma thing that you should be able to cancel it. Absolutely.
Yep. Another question from Sienna. How is child support determined in divorce?
We have a question from Sienna about the determination of child support in divorces. Well, Michigan has Michigan child support guidelines, and it's a formula that basically takes into account how many overnights the child is with dad, how many with mom, what the respective incomes are of the parties, and then it spits out a number. Genuinely speaking, that number is going to be the appropriate guideline that's going to govern the support. Now, there are times when a deviation from the guideline could occur, but that's generally under very extreme circumstances. For the most part, the guidelines are going to be followed based on the overnights and the respective incomes. Good question.
We have another question. So Megan's asking, how long does the divorce process take, and has COVID impacted the process in the way?
Here's a great question that Megan asks about the length of the divorce process and the interplay between that and COVID. Well, it is true that the COVID-19 format caused a lot of things to be adjourned. The court kicked the can down the road, particularly in the early months of COVID, and so things came to a grinding halt. Cases that should have only taken a few months ended up taking the bulk of the year because of COVID issues. Generally speaking, though, in a situation where we are right now, the court has adapted to Zoom format and other things that were required to address COVID. Therefore, we're kind of back to standard guidelines for the timetable on these cases, although there is still a backlog in many courts. Generally speaking, a divorce without children is calendared for 60 days, which means it can be prepared for finalization anytime after 60 days. If there are children, then the court sets up the calendar for 6 months. A case like that's normally going to take between 6 and 9 months to resolve, even without a COVID environment. So that gives you some time parameters and some idea of how long that process takes. Great question, though.
We have another question from Dave. Dave is asking, he would like to ask, who determines how assets are divided in a divorce?
Good question. So we get a question from David who wants to know who determines the division of assets in a divorce. Well, the system is set up so that the parties will get the first opportunity to determine how their assets and, for that part, liabilities will be divided. They get together with attorneys to try and hash out what's called a property settlement. But make no mistake, as the question suggests, if the parties cannot work that out, if there's an impediment to doing that, or they just can't agree on it, then guess what? The guy in the black robe is going to make the call. And the judge is ultimately going to decide how that property settlement will be worked out. And, frankly, you may not be happy with the court's understanding of that division. So therefore, it behooves the parties to make every effort to work it out amongst themselves. Generally, you're going to be happier in even begrudgingly working out a property settlement that you're not thrilled with. Sometimes that's better than having someone say, you shall do this and you shall do that. But that's the basic process for determining how property is divided. Great question.
Next question, Madeline is asking, do I have any options if I receive a final judgment in my child custody case and I'm unhappy with some of the outcomes and determination?
Madeline asks a great question. Do we have any leeway or any options if it is determined that you don't like the outcome in your child custody case? Well, you got to look at things from a general standpoint. Generally speaking, the options, if you don't like a verdict, is to appeal. And you would file an appropriate appeal, go to the Michigan Court of Appeals if you feel that the custody didn't work out properly. You don't have the same options with respect to property settlement because absent some kind of fraud, the court's usually not going to upset that. Even the Court of Appeals is not likely to go and say, oh, the judge allocated a piece of property to this person, but we think it should have gone to that person. It's very rare to see that. Custody, though, if you don't like the immediate decision, like I said, you can appeal it. The good thing, though, about custody and issues relating to children is that if someone's not happy with the situation, you can let it evolve a bit and file a petition before the court 6 months down the road, a year down the road, and say, hey, the court made this ruling, but there's been a change in circumstances, and therefore I want it to be revisited. Sometimes it's easier to go that route than to go through the Court of Appeals because remember, when you appeal something, you're basically saying, these are the facts, this is the law, this was what presented to this judge. We think you, Mr. Court of Appeals judge, you should rule differently, and you would have ruled differently had you been there. And that's a tougher sell. It's usually easier to reapproach the custody situation a little bit down the road and then try to get it modified. Great question.
Next question we have is regarding child custody. What's the best thing to do if I don't want to rock the boat with my child's father? However, I want something in writing to protect my child.
All right, so here's a great question that basically says, what do we want to do? We don't want to rock the boat with the child's father, but at the same time, we want to protect the custody. Well, I will tell you this. There's a lot of people that believe you can catch more flies with honey. They believe that we don't want to rock the boat. We don't want to get overly aggressive in protecting the rights through legal means. So therefore, we're going to try and work with the other parent. Sometimes working with the other parent is very effective. Sometimes it results in a sort of a loosey-goosey situation where nobody's rights are protected. I will tell you this. You can catch more flies with honey. If you're in the fly catching business, that's fantastic. When you're talking about your child and preserving the rights that are in the best interest of the child, you really can't analyze it based on entomology. You have to look at the situation. You've got to determine what's in the best interest of the child. If you feel that you are the best custodian, the other parent is unstable or for some reason volatile or not reliable as a custodian, you got to take the necessary steps. You got to go before the court and file that motion. If you're worried about rocking the boat, you got to evaluate, what are we doing? Are we worried more about rocking the boat or more about the child's best interest? If the answer is the latter, you're going to have to make the boat a secondary consideration and take the appropriate steps. Great question, though.
All right, the next question, if there are laws and guidelines already in place, why do these matters get so ugly and can last years?
Wow. That's a fantastic question. The question that John asks is, if there are already laws in place to govern the custody issues, why does it get so ugly, and why do these matters take so long to resolve? Well, the fact of the matter is there are laws in place that deal with general issues, but you have to understand something. You're not talking about buying a bag of apples here. These are matters that relate to the very delicate balance of trying to figure out what's in the best interest of a child. And many times, parties have different views of what's in the best interest. The COVID-19 thing was a perfect example. While half the people might have felt that it's imperative that the children get back to school because they're wasting valuable months of education, there was just as many people who would say, well, too bad. You got to keep it at home because we got to avoid the potential exposure to them and the spread of COVID-19. Two fairly legitimate schools of thought that were, obviously opposing each other. That's the kind of thing that can cause a matter to drag on. When we talk about child custody, we all know that we have to follow the child's best interest, but there are a dozen unevenly weighted factors that go into that, and skilled lawyers who are on both sides of that such a lawsuit can really make a situation where it's difficult for the judge to make the rulings. They can really provide things for the court to think about, and it takes time. And a lot of times, in order to determine the relative quality of the custodial environment, sometimes it's necessary to point out that one particular environment is hostile to the child's health. And in order to do that, it may be necessary to point out the weaknesses and the problems. Someone may be a drug addict or an alcoholic. So it can get messy. It can get ugly. And even though we have the laws that are supposedly there to govern the situation, but within those guidelines, there is a lot of play, and there is room to bring up certain things which could cause a litigation to elongate. Obviously, the parties try the best that they can to give the court the information that it needs to make an appropriate judgment. Great question, though.
So the next question, what would be my options if my spouse refuses to go to court despite being served with divorce papers?
Okay, this question comes from Cheryl from Livonia. What would be my options if my spouse is served, refuses to answer, doesn't cooperate, and what do I do? So that's a great question. Here's what to do. This is a perfect example why people have to be represented by lawyers, because lawyers know that if somebody evades service or refuses to participate in the, takes them and does nothing, won't participate in the litigation. Well, what the lawyers will do in the case of a lack of participation, they will file a petition for entry of default. This won't stop the divorce. This will keep going. The other guy just won't be able to weigh in on it. If the person is deliberately evading service, then there are methods of alternate service that are available, and skilled lawyers know how to use that system to get that guy served. People shouldn't think for a minute that if I don't take these papers, the divorce won't happen. It's like some people think if I don't go to the doctor, I'm going to live forever because there'll never be a diagnosis. That is not how the law works. You want to avoid service. All that's going to mean is you're not going to weigh in on crucial decisions regarding your future. And from the other side, if the other person won't take the papers, your attorney will know how to file a petition for alternate service and keep that case moving. Excellent question, though.
So the next question, can I refuse to allow visitation if my ex stops paying their child support?
Can you, I'm sorry, I didn't catch the question.
Can I refuse to allow visitation if my ex stops paying their child support?
This is a fantastic question. This question deals with the interplay between parenting time and child support. The question is, can I withhold parenting time if my ex isn't paying support? So there is a misconception that the two are related. The two run side by side. They are both there, but they are not interconnected. One does not stop the other. If you are not getting your support, you should be contacting your lawyer, filing a motion to show cause, filing a motion to bring it before the court that the other guy's not paying. The court can issue show causes, issue warrants, force payment, do income withholding, do all sorts of things to get you your support. But it's not a question of, two wrongs make a right. It's not a situation where just because he does something wrong, that should mean you should withhold parenting time. When you withhold parenting time, you take the law into your own hands. In a sense, you marginalize the authority of the judge. The judge is not going to like that. If there's anybody who cares about their own authority, it's the judge who cares. So don't do that. You're not getting your support, file a motion, but continue to do what you're supposed to do as it relates to your court orders. The court will take action on the other matter. If you don't allow the parenting time, all you're inviting is a motion from them to say you're not complying with the rules, and you don't want that to happen. So even though you would think that one sort of begets the other, and if I'm not getting this, I shouldn't do that, it's not how it works. Do not take the law into your own hands. Speak to your lawyer. He'll get the job done. Great question.
So the next question, as a family law attorney, are there reasons why you would discourage someone from getting a divorce?
So here's a great question about, as a family law attorney, do we ever discourage people from getting divorces? In my career, I have discouraged people from getting divorces. I've done that because I felt that it was an itch in one place and a scratch in another. I once had a couple married 52 years who came to me for a divorce, but when I got into it and I spoke to the parties, I realized that the problem was that after the gentleman's retirement, he was always around, and it drove his wife crazy. She interpreted that lack of familiarity, that uncomfortableness that she was now experiencing with him being home all the time, with a need to get divorced, and she was wrong. And we resolved that case. And all I did was enter into an agreement that guy will go to the health club 3 times a week from 9 in the morning till 3 in the afternoon. It's all she needed, and they stayed married. Sometimes lawyers, when they look into it, they will discourage people from getting divorced. Sometimes people think if they can't agree on spending habits, they should get divorced. Well, not necessarily. Sometimes it's a question of coming to an understanding of how people see things differently and coming to a compromise. Divorce should be the last thing you do as it relates to your family and your marriage. It shouldn't be your first step. It should be your last. Let's keep that in mind. Great question.
So the next question, what are the right steps to take if my ex keeps threatening to take my child out of state with him?
Okay, so the question, if you didn't hear it, is what are the steps that should be taken if the ex keeps threatening to take the child out of state? Well, really, you have to understand one thing. We here at the firm offer expertise in the law, but the people who call in with these questions, you're the country's leading expert in your spouse. You know whether or not the threat is real or not. If you genuinely think that you're at risk for the child to be removed from the jurisdiction, then you better take action. There should be a complaint for custody or divorce filed. There should be an order requested of the court that the child not be removed from the jurisdiction until further order of the court. There are steps you can take to make sure that doesn't happen legally. Because I'll tell you one thing. If it comes out that they take the child and they go to a different jurisdiction, so now you got to file motions and try to get the child back, that's going to present some real legal challenges to accomplish that. It's going to take a lot of time. It's going to be a lot of aggravation. It's going to be extremely costly in all different ways. So therefore, if you really think this is going on, you need to get ahead of it. You need to file the appropriate motions and get an order before the court. Very interesting inquiry.
So the next question, what age does my child have a say in living with what parent? I have a teenager and the rest are too young to make a decision. What would the court do in that situation?
Okay, so it's a very interesting question about the age at which children can express a preference when it comes to a custody case. Generally speaking, the court is going to look at, this is about a teenager, this particular question. The court will take into account the reasonable preference of a teenage child, but it won't carry the day any more so than if your child says, I don't want to go to school anymore, how about it? Children can say what they want to say, but remember, until they're 18, they don't get to make that decision. And if you're in a situation where your kid doesn't want to go visit dad, you're not in position to say to him, well, okay, you make that choice, because he doesn't. The judge makes that choice. Having said that, in a case of a teenager, the court will, in a private method, through private means, establish what the express preference of the minor child is. In that situation, the court will take it into account, but it's only one of 12 factors, 12 unevenly weighted factors that the court will consider in determining, where the children should go and in determining custody. Very good question, though. Interesting.
The next question, when having CPS involved in a case, does that usually prolong the process of child custody?
This question is about whether or not CPS prolongs the process of child custody. I would tell you that it does. Personally, not a huge fan of the CPS involvement in custody cases. The reason why that is because CPS involvement necessarily prolongs the process, because the court will typically, in deference to CPS involvement, set up periodic review dates where everybody has to keep coming back every couple months, every 90 days, coming back for more reviews, and more reviews. The clients don't like it. They don't like to pay for it. They don't like the imposition of that on the otherwise, custody case. They don't like that level of involvement. However, the fact of the matter is the courts generally, they give deference to CPS. So if you want to say that your child's been abused, the first question out of most judges' mouths is, yeah, did you call CPS? In other words, they seem to invite CPS. So I would say that if you're going to make a case where you're going to allege some kind of neglect or abuse, you're probably going to have to involve CPS, even though your particular lawyer might roll his eyes and say, gee, I wish you hadn't done that. But, and why? Because it will prolong the case. I've seen very few instances where CPA caused the case to hasten and to have a shorter lifespan. Generally speaking, CPS involvement is going to cause the case to elongate, no question about it.
So the next question, would a criminal record heavily impact someone's ability to receive parenting time with their child?
So here's an interesting question about the interplay between a criminal record and parenting time. The fact of the matter is there are many parents in happy unions where perhaps one or maybe even both have criminal records, have had criminal activity in their past. Just like it doesn't impact that situation necessarily, it doesn't mean that the court's going to deny you just because you have a criminal record. Remember one thing, folks, the courts are very much about what have you done for me lately. History is not of great interest to the court. So if somebody has a criminal record from 5, 6, 7, 10 years ago, the court's just not going to care. The court's going to say you've been a responsible adult of the last few years. The fact that you have a drunk driving or even an assault or some kind of criminal record, whatever, is usually not going to impact your parenting time. Where the court will look at criminal activity as it relates to parenting time is if it feels that the criminal activity is A, of an ongoing nature, and therefore B, something that might, expose the child to some level of risk or some corruptive influence. In that situation, the court might require that the parenting time be supervised or might otherwise limit the parenting time. As a general proposition, though, a prior criminal record that's simply historical will not overly weigh in on the issue of parenting time.
So the next question, what rights does an unmarried father have?
This question is, what rights does an unmarried father have? Well, it is true that in a marital union that results in a birth, there's a presumption that both parents are going to, share in the raising the child, custody rights of the child, parenting time. It's a shared proposition. In a non-marital union, you don't really have that same level of presumption. But having said that, a father has the right to go before the court and file a petition and ask for parenting time. And the court, assuming that is the father, sometimes there's DNA that has to be, taken and then the paternity established. But once that's done, the court will be favorably disposed to giving that dad a parenting time order. It won't be up to her. It won't be up to anybody's mood. It'll be up to the schedule that the court predetermines. And a lot of times the structure of that schedule is something that the parties rely on and really helps in establishing an appropriate relationship with the child. So the fathers have that rights. The only key is you got to go get them, which means you got to get your lawyer to go to court and file the appropriate motion, have a hearing, and get that order.
So the next question, what happens to pets or dogs during a divorce with the court intervening?
What a fabulous question. Comes up all the time. People want to know what happens to pets in a divorce. How does the court get involved? Well, I have to tell you, I have heard the courts make rulings about, the custody of a dog. I will tell you that, and I don't say this, I don't come from the standpoint of somebody who's not a pet lover. I myself have 2 doggies. And, so I don't mean to be uncharitable to them when I tell you that in the eyes of the law, a dog is like a chair. The court's not going to take any more interest in your dog than it would in a chair. The law looks at a dog as an item. It has to divide items in a divorce. It will divide your barking item in a divorce also. However, I will tell you that to spend thousands of dollars in a custody battle about a dog is about as smart as having spending thousands of dollars on the custody of a desk. Are we really going to do that? I don't know if you should. It might be a better idea. I suppose the parties can work out an arrangement. They could go 1 week on, 1 week off with the dog. It's a possibility that one could do that. But I think if you put the court in a position to have to rule on a dog, if you really care about the dog, get together with your wife, get together with your husband, figure out what we're going to do about the doggy. And that would be the smartest thing. Because remember what I said, in the eyes of the law, a dog is like a chair.
And so the next question, what happens if a parent does not pay court-ordered child support?
All right, so what happens if a parent doesn't pay support is our next question. You know, it's risky business. Not paying support is actually a violation of our Michigan criminal statutes. It doesn't mean that every time someone falls behind $1, the prosecutor comes knocking at your door. That's not what happens, certainly not most of the time. But the court has a lot of leeway. If somebody falls behind in support, the friend of the court is going to get after you. Oftentimes it'll result in show causes. You'll be hauled before the friend of the court referee, sometimes hauled before a judge. The court has all sorts of discretion to impose fines on you. The court can jail you. The court can sanction you. You can be held in contempt. Warrants can issue for your arrest. My message to you is this. If you're falling behind on your support, immediately file a motion to tell the court you're behind. Why are you behind? Maybe you lost the job. Maybe you're making less money, whatever it is. And see if you can get the court to suspend or lower the support. That's the key. Oh, excuse me. Wow.
Next question. This isn't about family law, but I see that your firm does dog bites. Can you give us an overview of what that process looks like?
Sure. It's funny, we had a dog question about custody of a dog, and sometimes we've had issues relating to the family pet, particularly relating to dog bites. In the state of Michigan, an owner of a dog is responsible for the actions of the dog, meaning that you have a responsibility to handle it appropriately and not negligently. If your dog bites someone, that's a violation of your own supervision requirements. You have a right to have your dog out there, but it's got to be on leash. You have a right to enjoy your dog, but your dog can't take a chunk out of somebody's knee and have you expect that nothing's going to happen as a result. If a dog bite occurs, you're going to be responsible. And there is no statute that allows for one free bite. There's no law that says you have to determine the propensity of the animal. And if the animal's otherwise calm and then bites someone, you're immune. There's no such thing in our state. It's a dog. A dog is a dog. It's an animal. And even though you love it, it's still totally capable of causing damage. And you as the owner are going to be responsible should that happen. The good news is that if you commit an act of negligence and your dog gets away from you and bites someone, it is covered. It is an item that's covered by your homeowner's insurance. They will defend and indemnify you and take care of it. So that's the good news. If you don't have homeowner's insurance, you're personally liable for that. That's not good news. If you don't have homeowner's insurance, go out and get some so that if you have a dog, you're protected from it because the losses can be very, very substantial. Great question.
Last question. Someone saying she's a survivor of domestic violence and she's trying to get sole custody of her children, and she's told that just because he abused her doesn't mean that he's not a fit father. What more proof does she need?
Very good question about the interplay between getting custody and domestic violence. Just because someone in the past committed an act of domestic violence does not necessarily mean that the other parent's always going to get the custody. It's true. Domestic violence in the household is a factor of about a dozen factors that the court has to weigh. The best thing a person can do to try and ensure that they will get custody in a future custody dispute is to make sure that the court can see its way clear to determining that you're the best parent suited for the job. That means you care about your child, you are involved in the school, you are involved in the medical issues regarding your child's going to look to you for all the emotional support. You want to make sure that you've done everything you can to be the best parent you can be, because if you've done that, the court will clearly see its way to giving you the nod when it comes to a custody dispute, particularly if the other guy, has the same issues but has domestic violence in his or her history. So I think if you want to figure out how best to, maneuver the system so that you will be the one that the court gives custody to, it's very simple, and you don't have to orchestrate it. Just be the best parent you can possibly be. And you know what? You may say, well, gee, what if the other side does that and he's the best parent also? Then what happens? How does that help me? Well, here's how it helps you. Your child now has access to two great parents. So you know what that situation should be? It should be a situation where both parents bring their great skills of parenting to the table and have the opportunity to have that influence the child's life. What a wonderful thing for a child to be parented by two people who are really making that level of effort. So if that's what's going on in your life, consider yourself lucky. I want to thank everybody for their questions. I think they were great questions. I think they really underscored some great issues that there are in family law. We will have further Facebook Lives, and we'll be glad to entertain other questions at that time. Thank you again for your participation.